Today's topic, very clickbaity on our part, exploring trademark strategies used by sports teams and celebrities. So we're going to cover a variety of really interesting trademark cases involving the renaming of sports teams and even what some celebrities are doing to protect their trademarks. If you have not joined a CLE of ours before, a little bit about our firm. I'm Josh Gerben. You also have today my law partner, Eric Perrott, and
Hey there.
Hey, Eric, and our marketing director, Lacey. We are celebrating our 16-year anniversary. Our firm currently consists of 9 lawyers and 4 paralegals. We're a little spread out. We cover pretty much everywhere down from Nashville, Tennessee, all the way up to Burlington, Vermont, very much on the East Coast for the most part. Over the last 16 years, we've registered over 8,000 trademarks for clients. That includes trademarks here in the United States and about 30 different countries around the world. We have settled a lot of the trademark disputes without the need for significant litigation, although our firm also does do federal litigation. We've overcome over 200 refusals of our clients' trademark applications with the United States Patent and Trademark Office, and we've handled several hundred trademark trial and appeal board cases, which is a quote-unquote court within the trademark office, administrative court, if you will. So our practice is pretty fun. We get to work with clients from all over the place since we are a federal practice. So we work with clients from all 50 states. And also we work with clients from a lot of different countries around the world, not only in helping protect trademarks around the world, but also in protecting foreign companies' rights here in the United States. So we kind of get to work with all kinds of people from all over the place, which keeps things interesting and fun for us. In today's CLE, we're going to cover, for the people just joining, trademark strategies that sports teams and celebrities have used to register their trademarks. And so here's a rundown of the things we're going to try to get to. We've only got an hour, so if we don't get to everything, we'll make the materials available. But some of the picks we have are 2 major rebrands of major sports teams in the last couple of years: the Washington Redskins to the Washington Commanders, and the Cleveland Indians to the Cleveland Guardians. Also have a fun case to talk about how Ohio State registered the word "the" as a trademark. More recently, Tiger Woods left Nike and started a new partnership with TaylorMade, and we have some fun details about how that trademark filing went down. A little bit of a father-son trademark battle between Shaq and his son Shaqir. And finally, just to keep everybody interested, and to the end, the most important one of all, Taylor Swift, and how she filed new trademark applications for the name of a new album just minutes after announcing it at the Grammys earlier this year or last year. I've lost track of time. Always just start these presentations with a quick reminder about what a trademark is, in case you're not familiar. But a trademark can be a lot of different things. It can be, obviously, it could be the business name, the product or service name, slogan for a company. It could be logo. It could be trade dress, like the way a restaurant looks and feels when you walk in. It can be protected. You can even protect sounds with the trademark. Very famous one there is Netflix's "ta-dum" when you sign on the Netflix at night after a long day of work. Colors can be protected as a trademark in certain circumstances, as well as patterns and shapes. These are the most obvious ones. Again, just to give you the example, Nike's always a favorite example because you have Nike. They have different product or shoe names. The slogan, "Just Do It," that everybody knows. And of course, the logo with the swoosh. And even the design of some of the shoes is registered as trade dress. So trademarks can be just about everything that you're interacting with that's lets you look at something and say, oh, I know what company's behind it. That's essentially what a trademark is. And actually, a lot of your clients probably have a lot more trademarks than they have registered or even know about. And so it's something just to be aware of when you're talking to clients and understand that they might have IP they can protect. That said, we'll roll into the presentation now. The first one we're going to cover is the Washington Commanders and the rebrand of the football team. This was an incredibly interesting matter that started around 2020, in the summer of 2020, when the Washington Redskins announced that they were going to get rid of that name and they were going to use an interim name called the Washington Football Team. As soon as they announced this, you started to see squatters file names with the United States Patent and Trademark Office trying to guess what the actual permanent name would be. So you had dozens and dozens of applications start coming into the trademark office with various different names. After about a year, it actually took a little longer than a year, the Washington football team, as it was known at that time, confirmed that they had 8 unofficial finalists for names. So at that point, they said, look, we've narrowed this field down of all the potential names to 8. And there was even a news interview with the team's president that said, they're reviewing things from a trademark perspective, as well as, what the fan base would like to see, because they knew, anytime you would have an NFL franchise rename a team, this is high stakes. If there is an infringement of someone else's trademark, there could be a lot of liability and a lot of embarrassment for the team should the rebranding not go well. So lo and behold, after announcing in September of 2021 that they were down to some 8 names, in February of 2022, they've officially announced that they're going to be the Washington Commanders. And at that point, they started filing the trademark applications with the USPTO. So they make the public announcement, and then days later, the filings come into the PTO. And what we're able to see in the trademark application that was filed with the USPTO after the public announcement is that they had actually filed the Commander's trademark application in a small island country in the Caribbean, Trinidad and Tobago. This application was filed back in August of 2021. So keep in mind, August 2021, they haven't even announced they have finalists for the name at this point, but they'd already filed that trademark in Trinidad and Tobago. And you could see here, this is the actual USPTO application. This is how they look when you look at them online. You could see this claim that was made in the application. And I'll go over what this means, but it said, we have a section 44D basically filing basis, which indicates that one of the basis for this filing is an application we filed in another country, and we filed the application in Trinidad and Tobago. Okay, so why on earth would the Washington Commanders, a United States football team, want to file in Trinidad and Tobago? There is an international treaty called the Paris Convention. And what this treaty says is that for all the countries that are signatories to it, of which there's about 180, if you file an application in one of these countries, so long as you make a filing in another country within a 6-month window, okay, now you get the priority date of that original filing, wherever that might be. So this is why the Commanders filed an application on August 6, 2021 in Trinidad and Tobago, and followed it up with a filing in very early February within 6 months in the United States. Because now when they filed this application in the United States, the effective filing date is August 6, 2021. So any squatter or anybody that might have discovered this name or had even come up with the name in that 6-month period would sit behind the Commanders in line at the PTO. So this is common for very large companies that have big product launches. They want to hide the name, but they want to get protection on the name, because ultimately the Commanders would have zero protection on that name until they file the application with the USPTO or would have started to use the trademark in the marketplace in the US. And there's all that time between the time the name is selected and the time the name is either used or filed with the trademark office that anybody else filing an application with the USPTO could jump them in line, have priority, and ultimately have really good legal claims against them.
And I think, Josh, loose lips sink ships. I think there's so many people involved with this process that we see this every day. Oh, the leak of whatever happened. So I think that uniforms, all that kind of stuff, that all leaks so quickly and so frequently that it would be probably a guarantee that someone would have seen this before they had a chance to make some filings. So I think I agree that the way to go.
And Eric, if you remember, now me as an Eagles fan, I love when the Washington Commanders mess things up, right? So the best part about this whole launch is the night before they were going to do the reveal, they changed around all the interior of the FedEx field, and they actually put up the gift shop for the Washington Commanders. And there was a news helicopter that was flying over the stadium and took a picture inside and could see the name and see everything. So the news broke before the Commanders were even making the announcement. Everybody knew what the name was going to be because they didn't conceal the stadium enough from the air, so to speak. So it was a major coup for the local news team. But also, again, somebody could have run out that night and filed a trademark application had they not had this air cover from the Trinidad and Tobago filing.
And from the chat, so why don't squatters just check all of those databases? That is because there is no public database in Trinidad and Tobago. We've even perhaps inquired as to how we may get alerted, and they said that doesn't exist. We don't provide that. And for example, Honduras, the official contact for the trademark office has an msn.com email address. And so, yeah, this is something that is very protected and private. It is not something that they would have a public database, and they purposely target countries like that, like Trinidad and Tobago, that will keep that private.
Right. And I mean, quite frankly, I think that these trademark registers, we'll talk about the next one in a second, which is in Mauritius, which is I never even knew about that country till, I discovered people filed trademarks there. These trademark offices make some money from these filing fees because people know if they file there, there's no one that's going to be able to find it. And I've definitely even called up trying to run searches to see if we could find out what trademarks Apple computer has filed or other, they won't really divulge that information. And so they do a pretty good job of trying to keep it secret, knowing that is one of the reasons they remain relevant and actually receive filing fees, especially from larger companies. So Eric, I mean, we have another one here, a similar but different, somewhat different story for the Cleveland Indians and the Guardians.
Yeah, so the Cleveland Guardians, they announced that they would no longer be the Cleveland Indians after a very long time of having that name. And they announced that it would be the Cleveland Guardians. I believe after a bridge. Is that where the Guardians comes from? I forget exactly where it came from, but they did a similar thing where they filed in Mauritius, kind of small island country that they filed it well before they had actually made the announcement. So they had made the announcement in 2022. They filed it in 2021. But in this case, they were able to get before everyone on the register, but they had an issue where once they announced, out of the woodwork, there came the Cleveland Guardians roller derby team. And so this was a roller derby team for several years. They had what looked like somewhat inactive or not very lively presence on the internet, but they did send a cease and desist letter, and it became a public thing because it started going around when they announced Cleveland Guardians. They said, well, look what the social media found a roller derby team. And so they did reach out to the team, and there was not a clear resolution. Ultimately, they did not oppose the trademark application, and they may have had a claim, they may not. We didn't really learn much about what happened after that because it kind of just was either settled quietly or perhaps they ran out of steam or money to attack it. But it was a situation in which when Josh and I do these search reports, it's always, I talk about it less about the idea that I am in the business of protecting trademarks and I'm more about managing risk. Like that is what we do is, you're always going to accept some level of risk when you decide on a new trademark. It's never going to be that you are going to be 100%, no one could ever cause a problem for you. And so I think this is one of those cases where I'm sure when they were doing this search, someone, had to consider, well, there are other sports teams that use guard, that use guardian, and this is one that ultimately did not prevent them from shifting to the new name, but it's definitely something that goes into this bigger picture of how to pick a new name, how much risk are you willing to accept, and then what do you do when one of those things might kind of be very public from a PR standpoint and from a legal standpoint. And this one, it looks like we didn't hear much about it after the first kind of shots across the bow were made, and so likely that means they found a way to coexist and to figure it out. But this is one that was pretty high profile for a minute, and the Cleveland Guardians did what they could do beforehand as far as filing with the Patent and Trademark Office, which the roller derby team never did.
And I think that's a great point, is that if the roller derby team had actually filed a trademark application for Cleveland Guardians, I don't think the Cleveland Guardians are the Cleveland Guardians. Quite frankly, I mean, obviously roller derby team, MLB team, there's also the discussion of whether or not they're really going to be confusingly similar. But the idea that they're both Cleveland Guardians or both Cleveland based, I think the team would have probably shied away from it if the roller derby team was really active and, had a more active presence and looked like they were still, because it really looked like the team had disbanded or wasn't really being used for a few years. But if they were active and they had a trademark registration, it's very likely the MLB team chooses a different name, I think, or at least has to have much stronger conversations about what a buyout looks like before they announce. So, just one other thing to think about there for your clients, that if you do have a federal registration, the deterrent value of having a registration on the register, is really important. And it also, it can lead to more fruitful settlement negotiations if an issue ever arises. So
yeah, and so in the chat, someone asked about, well, as far as filing strategies, how long do they get? They filed in this other country. Well, then what? And so the answer to that is actually, so it's a little bit of a in the weeds response, but when you file under 44D, you're not actually saying that you're going to register the trademark based on a foreign registration, because that's only available for foreign entities. And so what they would have done is they would have gotten that filing basis, and then they would have had to file proof of use in the United States in order to register the trademark. And so they are reserving it insofar as they get the priority date and things like that. So they get the protection date as when they applied, but they are going to eventually have to use it in order to register it. And that's normally within what's called an intent to use application time. So merely filing in Trinidad and Tobago does not give them the ability to register it. It just gives them the ability to apply, and then they have to use it in the United States before they're able to register it.
And one quick other question from the chat I saw about how do you register a trademark in a foreign country? That's a presentation for another day, perhaps. I think one we might have already done. But one of the ways that we would do it here, we have made our own filings in other countries like this, is that we would have a local attorney file it. You would call up, you would find an attorney. Typically, we develop relationships over time, but we have people in different countries that we will call and say, we need to submit this application. And because they are licensed in that country, they will then go ahead and make sure it meets all the local requirements and then file it on behalf of the client. So it's almost like a little bit of a subcontractor, if you will. But in our world, it's called a local counsel. Different from a federal litigation local counsel. It's actually local counsel in the country in which you need to make the filing. But it's common practice in trademark law that you would use attorneys in other countries, and then they would use you when they need to make one in the United States. So sometimes a little bit of reciprocal business occurs in those situations too. But yeah, that's the easiest way. Is just call somebody up in that area and get a filing made. So the next one on our list is Ohio State University. For those that are familiar with Ohio State, if you may have seen when a player gets on Saturday and you're watching college football and they are doing their own announcements, they'll be very keen to say we are from the Ohio State University. It's something that is, if you've ever talked to someone that went to the school, no offense, if there's anybody on this call, they might be slightly obnoxious about it, but nevertheless, Ohio State also then filed a trademark application for the word "the," which quite frankly provided a lot of great clickbait and news articles, because everyone was like, well, how could somebody trademark the word "the"? The application that Ohio State did file for the word "the" was for a brand of clothing. So trademarks are always limited to the products or services listed in an application. It's not this broad claim that they just own the word "the." That's, of course, what everybody thought. That is not what happened. But that's what Ohio State was trying to do, is protect the word "the" for a brand of clothing. They filed this application back in August of 2019. It got reviewed very quickly. I can go over why, but that's sort of immaterial to the call here today. It got reviewed a couple of weeks later by the PTO and was actually denied. The PTO found two reasons to refuse the application. One was that a clothing maker, Marc Jacobs, already had its own trademark application for the word "the" filed. So Marc Jacobs beat Ohio State to the trademark office, filed it first. University also had a poor specimen. So This is what they had submitted initially to show that the trademark was being used, a large "the" on the front of a shirt. You can imagine getting this in the Christmas stocking. Anyhow, this is an improper trademark use. If you have a client that says, oh, I'm using a trademark, and they send you the picture of a shirt or a hat and just has the trademark plastered on it, that is what we call in our world an ornamental use. So it just means it's ornamental. It's on the front of a shirt. It's not a brand. In order to have a branded use, it has to go in an area like the neck tag. So here is the substitute specimen that Ohio State ultimately filed. And you can see how "the" is now in the neck tag area. This is considered a branded use. It also could have been on tags like hang tags or something like that for the shirt. So Ohio State was able to get around that technical requirement. They still had to deal with Marc Jacobs. And so what ends up happening is that Ohio State makes a priority claims telling Marc Jacobs, look, we've been using "the" for longer than you've been using "the." The arguments that these lawyers must get paid to make are just always amazing. But anyhow, they did a settlement, and here's what they did. They both were able to get their trademarks approved by the trademark office by putting in channel of trade restrictions. So Ohio State said in their application that their goods would, their goods would only be sold through channels customary to the field of sports and collegiate athletes. And Marc Jacobs would only sell their products through channels customary to the field of contemporary fashion. And with those statements in each competing application, along with an agreement that told the trademark office both companies were okay with it, then the trademark applications were able to proceed. So lesson learned here, if you have a client that has leverage in negotiations or enough leverage in negotiations, you can coexist with other parties. You don't have to litigate it out to the end. You can find really creative ways to try to coexist and both get a registration on something that is either identical or very similar by putting certain restrictions into the applications.
So, yeah, how did Ohio State get their application examined so quickly? I think that often what happens is that when an application is filed and then there's other pending applications that have been filed several months earlier, they try to keep them all together. Usually the policy reason is that they're supposed to have some connection to each other. Sometimes they just say, hey, here's them all. I'm just going to grab them all at once so that they're all kind of consistently with the same examiner rather than getting 6 different examiners on your 6 different applications. And so those will all get grouped together sometimes. I've been told they don't do that as frequently anymore because they realize people were kind of trying to time it so they could get them all done at once, but it still happens. And that's always a surprise when everything gets reviewed in a week or two. And you're like, wait, what in the world happened here? And then you realize, oh, it's because it's grouped with ones we filed 6 months ago. So there is a way to get an expedited review of a trademark application, and that is through what's called a petition to make special. That is a topic for another time, I think, but it's really if you have either a renewal that you forgot to file a renewal for and it got canceled, there's a way to kind of jump the line and get that reviewed very quickly. Or if you're dealing with counterfeits or infringement and you can show proof of it, then that's something that you can, and at the office's discretion, they can allow you to review. It doesn't shorten it by it doesn't make it so that they'd be reviewed in like a month. It's usually about 2 to 3 months instead, because it still has to be reviewed by a petitions office. But those are very rare circumstances. Most of the time, everyone has to wait in line. Right now, waiting in line means waiting about, I think we're at the tail end of 7 months, about 7.5 to 8 months. If you applied now, that's when your application will be reviewed by the Patent and Trademark Office. And that number is slowly going down. Right now, we're looking at things that were about 9 months ago, but that number keeps every month getting a little bit lower based on efforts by the Patent and Trademark Office to make that lower, just not as quickly as we'd like.
Great summary. And thank you everybody for the questions. Please keep them coming. We'll certainly try to get to most of them as we go forward here. We got about 30 minutes left or so. So questions are always helpful for getting us to time and making sure we get the full hour. We still have a few things to cover. So the next one is so we've talked about a couple of issues so far. This one is unique in the sense that Tiger Woods, for those that are familiar, was a Nike athlete forever, right? You would see him all the time with the Nike swoosh on his hat when he was playing. And last year he made the jump from Nike to TaylorMade. And that was a really big deal in the sports world. And there was a number of trademark applications made around a new brand that he launched with TaylorMade. And the brand was called Sunday Red. The reason it's called Sunday Red is that Tiger Woods, if he's in contention on a Sunday, golf tournaments typically were 4 days, Thursday, Friday, Saturday, and Sunday. The ones that make it to Sunday that are still playing are the ones in contention to win or be at the top of the leaderboard. He would always wear red on Sunday. That was like his thing, right? So then I thought it was actually a really cool name, Sunday Red. Like it made a lot of sense. The challenge for TaylorMade and Tiger here was actually that they had started having conversations about him joining TaylorMade before his Nike contract was over and before he was ready to announce that he was leaving Nike. So I'm going to walk you through the timeline here and just work with me for a second, because I think you'll see it gets really interesting as we go forward. In March of 2023, so just last March, a company named TaylorMade Lifestyle Ventures LLC was formed. The reason this is significant is that TaylorMade Lifestyle Ventures LLC did not own any of TaylorMade's trademark applications at the time. It was just a new entity that they made. The reason that's significant is that people like me might watch the trademark office for any filings that these larger companies are making. So if they had filed something in TaylorMade Lifestyle Ventures around Tiger Woods, it would have set off alarm bells. In June and July of that summer, they did file the Sunday Red trademark in Jamaica. So for the same reason we talked about the trademark filings that the Washington Commanders made in Trinidad and Tobago and the Cleveland Guardians made in Mauritius, TaylorMade made these filings down in Jamaica, which has a similar sort of hidden trademark database. Then in December of 2023, TaylorMade filed various applications for Sunday Red in the with the USPTO. So again, you look at the dates here, you're 6 months to the day from the Jamaica filing to the USPTO filing, and that's to take advantage of that 6-month priority period. Then in January, so this is, as we get into the 2024 year, Tiger and Nike finally announced are ending their 27-year partnership. A week later, essentially, TaylorMade makes the rest of the filings that they had started to make in Jamaica and the United States. And then in February, Tiger Woods and TaylorMade announced that they're partnering together and will create a brand called Sunday Red. So the reason that timeline is so interesting is that, I'll back up for 1 second. The actual partnership between TaylorMade and Tiger was not made until February of 2024. However, if you recall, they created this new entity back in March of 2023. So we're talking about almost an entire year that Tiger and TaylorMade were clearly working together to get this brand developed and get the new trademarks filed while he was still under contract with Nike. And they did it in a way where Nike probably wouldn't have ever known about it. Now, maybe there was more conversations going behind the scenes, but Nike theoretically wouldn't have known about it. And nobody could find these applications because A, they made a completely new entity name. B, they filed them down in Jamaica. And even when they filed them in December in the United States, no one picked up on them, again, because it wasn't the usual TaylorMade entity that files all their other trademarks. So they did a really good job of hiding this from everybody. And it came back to forming new companies, filing overseas, and then ultimately filing in the United States. So you could tell how much thought and energy and effort went into doing this, especially given the sensitivity of needing to walk away from the Nike contract without basically being a lame duck for 10 months and announcing it in April of 23, I'm leaving in January. Like that would have been bad for Nike, probably bad for Tiger too in some capacity. So being able to get this new brand all put together and done while under contract with another company, that is not something I had seen an athlete do before. And I thought it was, quite frankly, really well done by all the attorneys involved. So here we are now. Tiger is a TaylorMade athlete, so to speak, and you can buy your Sunday Red merchandise wherever TaylorMade products are sold.
Yeah, I think this is a good example of it being done very smoothly. I think we've got a lot of other examples of when sports stars do leave their companies. I'm thinking of the Federer Uniqlo partnership that he left. Now I'm going to forget who he was with originally, but he had this logo that had his initials in it.
Nike.
And oh, it was Nike. Okay, so it was also Nike. Yeah, and there was a really big open question of, is he now, like, this symbol that he's been known for years, it does not belong to him, and it was something that he was not able to use moving forward, and basically all the goodwill in that symbol was something locked up in that partnership with Nike. It was not something that he was, unless they up with some kind of agreement that, but now they it had to start basically fresh with a brand new logo and, with a new company, and that even though it was made in this partnership. I think another one was it was a Kawhi Leonard had a dispute, and it was over who owns the copyright in his logo. And he's like, well, I drew this kind of squiggly thing and then I gave it to the company. Was that also Nike?
Yeah.
Yeah. Okay. So if you're taking notes on no, but and yeah, they had these, and it's something that, yeah, that kind of thing you really have to think about really early on in the relationship of who owns what and what happens when I leave. And I think that a lot of people, they're very young in their careers. They don't have the bargaining power to say, hey,
Yeah.
Nike, I want rights in this if I leave. And, then they end up kind of scrambling to try to figure it out later. I think Tiger Woods was in a position where he had all of the leverage when it comes to building a new brand. But, a lot of athletes might not have that, and be able to pivot in that way.
Yeah. And if you just want to know how much checkers and not chess that TaylorMade and Tiger were playing, I'll finish it up with this. So there was actually another Sunday Red trademark that was registered by a Texas man all the way back in 2009. And it was still registered when they were selecting this brand. So what ends up happening is that an entity that was created called EC Trade Co. LLC. This is an entity formed in August of 23. So remember, in 2023 is when we're kind of going through all the work that they're putting in, all the legwork they're putting in to make these filings. So EC Trade Co. acquired this Sunday Red trademark in 2023. It ultimately transfers it to TaylorMade Lifestyle Ventures, that entity that they had created specifically for Tiger's trademarks, a few months later. Here's the documents. I mean, these are the actual documents that were filed with the trademark office. So you can see here, this is the gentleman, Ernest Ray Harrison. You can see receiving party data. That means that's the company that bought and acquired the trademark with the trademark office. And then EC Trade Co. again assigns it to TaylorMade Lifestyle Ventures. So what they went out and did is they said, look, they likely did a clearance search, said we have this registration that's going to block anything we file, and or this gentleman might want to make a claim. They went out and I mean, what I would presume happened, although I don't have personal knowledge, is that they bought this trademark from this gentleman, transferred it to that shell entity, and then ultimately transferred it to TaylorMade. Why does the entity that they transferred it to more of a shell entity? Because if you went to this guy and said, hey, we're TaylorMade and Tiger and we want Sunday Red, you can imagine what it would have cost to acquire that trademark, as opposed to, oh, we're some company and we would like to acquire this trademark for you. Maybe who knows what they spent on it, but even if they spent $15,000 or $20,000, it's probably money really well spent. It's kind of found money for that guy in all likelihood. I don't think he was doing a lot with the brand, but it is one of those things where if they had not preempted it and had announced that they were going to be Sunday Red, all of a sudden that guy probably feels like he's sitting on a gold mine, and wouldn't necessarily be wrong. Although, what things are worth is always up for debate, but nevertheless, having done that before they even made an announcement that they were going to use Sunday Red, again, quite frankly, a checkers game and not chess that they were playing there.
And so the next kind of one we're going to shine a spotlight on is actually one that is a very personal family battle of the trademarks, but as we'll get into, not quite, more of a corporate issue than a father and son issue. But Shaquille O'Neal, his son Shaqir O'Neal, filed a trademark application for his name, but Shaq has owned trademarks for all kinds of different Shaquille O'Neal, Shaq, all different types of marks and they're owned by a company named Authentic Brand Group. Authentic Brand Group is one of these companies that controls the uh, rights and the names for a bunch of different celebrities. So they own the Elvis portfolio, the Marilyn Monroe portfolio. Shaq does have an ownership interest in the company, and that looks like it was at least related to when he provided his rights to the company. He became a shareholder in it. And so, this is, all to say that he likely at least gets some benefit from, the name. We've seen this sometimes where celebrities will sign over their rights, and then you'll start seeing it appear just all over the place. So you'll have one I'm thinking of from a long time ago is like Martha Stewart has not owned the Martha Stewart brand herself for decades. It's been owned by a company whose sole purpose is to sell as much branded stuff as possible. And many celebrities do this. This is not unusual. It's something that it would actually, I think, be quite strange if Shaq was kind of like, shopping around pillowcases with his name on it and things like that. It is something that these types of companies are great at doing this. This is what they do, and they form licensing opportunities, but it can get out of the actual person's hands. So, the estate of Elvis, for example, has once they transfer the rights over here, then the ability to enforce that trademark lives with the brand owner, which is this is Authentic Brand Group. And so that all came to a head when Shaquille O'Neal's son, Shaqir, filed trademarks for his name, for the name Shaqir O'Neal. I believe it was for apparel items, because he was going to do potentially a clothing brand that's called Shaqir O'Neal. And lo and behold, got through the entire process, and ABG opposed it, saying that it was an infringement of Shaq's trademark rights, um, because it was unrestricted. He was Shaqir O'Neal, and there was no agreement, presumably, at that time. And so what we can see through the different back and forths and through the filings that were made with the Patent and Trademark Office is that the opposition was eventually withdrawn. There was a coexistence agreement that was entered in between them, likely restricting kind of how the name's going to be used. And the key is here that don't ever assume just because it's your name, just because it's a mark you've been using for a long time, never assume that the trademark is clear, because it very well could be something that it comes up when your own dad stands in the way of you getting your trademark registration, and you can't run to him to fix it, because he, see, like most of us deal with, where we sell our rights to a company. And no, but this is a special occasion. But I think it goes to a much broader sense of really looking at all the different angles when it comes to adopting a new trademark, and not ever assuming that you're just going to sail through without any problems.
It also brings up the important point that I should not have named one of my children Josh Gerben, because he's going to have a horrible time getting any trademarks registered for himself if he needs it one day. So
it's going to have to come to the source, as long as you don't sell it to ABJ. Do you think they're looking for trademark attorneys to add to the roster?
You know, you all won't see me on these CLEs if ABG comes calling. That's all I got to say. Well, we've
and
got.
so from the chat is how, so this is going back to the issues of what happens if someone does squat. What do you do? How does an investigator investigate whether this is just a squatter who's trying to jump ahead of you in line in a trademark filing versus a legitimate user? Good news is that if you are a squatter, you see, I saw the Redskins are looking to rebrand. I'm going to put in a trademark application. This happens a lot, and you do have to have something at the bare minimum to file a trademark application. You must have a bona fide intent to use that trademark. Your intent can't just be, my intent is to sell it to the person who wants to use it. You actually have to have documentary evidence that this is a real thing, that you can provide these, and that you actually have a plan to do it. It's a low bar. You don't need to have a prototype. You don't need to have anything like that. But there is a bar that must be set. And when it's clear that you're through an investigation, trademarks are actually one of the few places where you can do something called a pretextual investigation, a pretext, that you can have an investigator go out as a normal consumer and reach out and say, hey, I saw this is on the register. Like, I really like this name. What do you plan to do with it? And as long as you're acting like a normal consumer, those are generally allowed. You can't say I'm an investor, I want to, and you can't go beyond that. But there are some ways that you can start to investigate whether this is a squatter or whether this is an actual person who by chance, there are millions of trademark registrations. I would never assume bad faith just when it could be someone who had the same idea a week before you. If you're a celebrity, I think, a little different because there's a lot more at stake there. But we've had situations where two identical marks were filed on the same day, and the person who got to use it was the person whose serial number was lower. And so that happens. And so I think it goes on to filing strategy of getting that in early. But those are ways that you can at least start to investigate whether or not someone is trying to squat on your name, is through those kind of questions of, well, could they even provide this? Do they have any kind of business background? Are they a kind of company who would do this?
That's a great point. We did get another question in, and before I move on from the sports topic, are college athletes protecting names, especially as NIL has kind of taken off, the name, image, and likeness, and the ability to profit off of your name, image, and likeness at the college level. Certainly, we've seen college athletes making trademark filings. We've actually done a number of filings for different collegiate athletes because of NIL. I will say there was also like a quick ramp up and then like a really quick drop off to this. And I think that part of it is that the market's still a little uneasy. Obviously, you have your very high profile athletes that should be protecting their name. If they have nicknames and things like that, those are all great trademarks to be filed. There's also an economics to it. Like when we talk to these collegiate athletes that might be getting deals for $20,000 or $30,000 or whatever it might be that they're doing an advertising campaign for, they don't want to spend a couple $1,000s to get a trademark registered. And, they're also very young. I mean, we're talking about people that are 18, 19, 20 years old and don't really see the long-term value that this might be creating from a trademark registration perspective or what problems might come downstream. So I don't think we're seeing as much of it as we thought we would see, although we're certainly seeing enough of it, especially with the higher profile athletes that are getting really good legal counsel that, hey, yeah, just get these things filed and, keep up with anything that's happening. So definitely something that's been new to the trademark space because of the NIL rules, but also not quite the gold rush that we might have thought it was going to be. I think that just has to do with the lack of business sophistication at that level. So the smaller deals, just, you're not getting the business counseling that the professional athletes will get.
Yeah, and jumping around a little bit is someone asked a question in the chat about, when you're trying to establish who used a trademark first or who should get rights, one of the ways is who used it first, or who filed the application. And if someone used it before you filed the application, they could still have rights in it. But the question in the chat is, what protection does registering a domain name give you? And the answer is, if all you did is register a domain name, then that is typically not going to be a trademark use and really does not go towards intent. I mean, perhaps in the case of trying to prove that you've got a bona fide intent to use, if you could show, well, that was a business activity I did. I think that the biggest thing is to never rely on a domain name registration in order to make that your public use. Same thing with business filings, that if you file with the state and you call yourselves, Gerben LLC, that does not mean you can call yourself Gerben Law. And because you can register whatever you want with the state, that doesn't give you trademark rights in it. You actually have to be using it. And so I think that is definitely something that you would need to show more than just kind of a registration. You have to show active ability to use it, things like that, in order to even start to kind of be in that realm. But really filing the trademark application is going to be, and I think I'm conflating two different things when it comes to bona fide intent to use versus actual use. So I think that's a topic for a completely, separate thing, because that gets into the weeds. But when that I think is something that just for the most part, domain names, just the registering of them, don't give any kind of trademark rights.
Taylor Swift is perhaps one of the most astute entertainers when it comes to trademarks and copyrights. I mean, she has a portfolio of trademarks that is pretty much second to none. And on her most recent album announcement, the Tortured Poets Department, she was at the Grammys and announced this this was February 4th of last year. And so we're talking about the same day and within minutes. This is what's fascinating about it. So 9:32 p.m. Eastern, Taylor tweets a picture of her new album cover for the Tortured Poets Department. At 9:42, we're talking 10 minutes later, the first of 4 trademark applications get filed by her legal team. And ultimately, by 10 o'clock, the legal team was done filing trademark applications. So within 10 minutes, they get the first one filed, and within 18 minutes, they get them all filed. This goes back to something that Eric was saying about, if you have a lower serial number, like the person that, if you were filing it on the same day, the person that files it earlier is going to be the rightful owner. So getting these filed really quickly after the announcement was important. Now, after having gone through the rest of our presentation today, you might be asking yourself, well, why wouldn't they have just filed this in Mauritius, or why wouldn't they have just filed this in Jamaica? Honestly, I think it's a great question. They probably had their reasons for it, and I don't know why they wouldn't have maybe tried to do that here. Nevertheless, and you know what? Maybe they were filed there and they just didn't need to use it for some reason, or they didn't. There's all sorts of different strategy that goes into things, but. They would have certainly not wanted to have filed these before Taylor was ready to make the announcement, because the PTO records are public and a lot of people filed Taylor's trademark application. So by waiting to make any filings, they obviously avoid leaking the news. And Taylor probably has a very narrow group of people that were aware of what this was going to be called. And obviously you have run the risk, especially with someone that has Taylor Swift's fame, that you're going to have squatters show up immediately. So I was obviously impressed that the legal team had coordinated with knowing that, with Taylor's probably very close personal team, that this announcement was going to be made at the Grammys, and somebody had to have this queued up and ready to file at the trademark office, within minutes of that announcement being made. So that's one of the fun parts about being a trademark attorney, though. I mean, whoever filed it that night is probably sitting there at some point telling somebody, yeah, I had to watch the Grammys tonight because as soon as Taylor announced this, I had to make these trademark filings. So, I mean, the real, you hear a lot about the trials and tribulations of working at Big Law, but I would argue that, that wasn't such a bad night for whatever partner or associate was up on it. That's our Taylor Swift story for today. A few questions rolled in there, Eric. I don't know. I'll start.
Yeah, and I'll first say that if you, as much as I give Josh a lot of grief for this, if you're looking for these types of filings and you're interested in who's filing what, Josh really reports on this a lot on social media. So follow Josh. You will get to see all of these in real time as they come in, because they are under the different things, the different names that we recognize and then report on. Even if they try to change them, we're still looking for them sometimes, and sometimes they sneak through. But so one of the questions in the chat was actually that, why don't they just file them in shell companies, and then we have no idea who they are until the announcement's made, and then that becomes that. And the most difficult part about a shell company is that it's actually a very technical USPTO problem. But the gist of it is that the owner of the trademark, from a very literal sense, the person who has control over the mark, must be the applicant. If you file in the wrong name, then that is a void application, and it is possible that if you file in a company whose sole purpose is to file a trademark, that does not give you the intent to use that you need to actually file it. And you actually cannot assign an intent to use application that is made in that purpose. So the shell company would actually have to be the operating company for at least a short period of time in order for them to register that trademark, because there is a prohibition in filing an intent to use application and then trying to assign it to someone else that is not there's exceptions to it. But really the takeaway there is that if a shell company files it, you have to be very careful that that is not a improper owner and could in 10 years even, or 5 years, be something that someone says, well, that was never the owner in the first place. This registration never should have existed in the first place. And so you have to be very careful about that.
Yeah. There's also a comment here about the 10 minutes was too long, which, between the, it's interesting that comment though, because I cannot tell you how many times we've gone onto the PTO database or PTO system to make a filing, and we can't make it because they have a technical outage or they have a technical problem or their payment system's down and you can't submit filing fees. So it is actually a real problem. Like if you're trying to make a filing on an urgent basis, you're actually relying that they're going to be up and operating. And that's why, again, sometimes, we're obviously dissecting what we can see from a public perspective here. And as you can see, some of these things are, we were able to dive in on, especially on the Tiger Woods one. You could find things like all the assignments that were filed, where the marks they acquired. You can look at the companies they created, but sometimes there's things that happen beyond the public view. And one of the things with these Taylor Swift applications that you almost have to believe is that they had something hidden somewhere offshore. If they needed to use it, they could. It would be really surprising to me if they hadn't. Maybe one reason they wouldn't have done that is if the name of the album really wasn't decided up until the last day or so before they were going to make the announcement, which is also possible. So there's always, you never know what's going on the client side there. They might not have had it planned out, and it might have just been something that they finally said, hey, we're going to announce this tomorrow. Can you make the trademark filings? In which case you say, yeah, we'll make it as soon as you're done making the announcement, kind of thing or whatever. So I think but yes, you're right. I think waiting till, if they had nothing else filed anywhere in the world from a Paris convention perspective, they run the risk the PTO website would have crashed. And that could have been a problem. So I think it's a legitimate concern.
And actually a really interesting question is, well, what happens if their application in that foreign country gets denied? And the answer is it does actually not matter. It does not matter that you register it in a foreign country. It only matters that you applied, because you're getting that priority date. And this is a thing that has been debated by trademark nerds over the past few years. The Paris Convention is, I believe, almost 100 years old. It is an old convention from back when they put the applications on a steamboat and basically just come across the ocean with them, and you need 6 months to do that. And so nowadays it's a much more different circumstance, but it's now strategies that are being used that are completely devoid of any real considerations from back then, when you had situations where something might not get from Trinidad and Tobago to other countries in as quick as they do now. So this is kind of an exploitation of a treaty obligation, but it does not matter if they even register that, as long as they applied.
We have 1 or 2 minutes left. There's an interesting practice tip that I want to give around this, because we've actually seen this happen a couple of times now with the trademark office, which is that if you have a client that files a trademark application, but there's somebody that actually like, let's say you are filing and you're trying to claim a Paris Convention priority, you have to make sure that the trademark office is giving you that right, because of how slow it is to process applications. We've had people that technically have priority based on the fact they have an Australian application filed, and then they come and they file their US one. But because there was something in the US filed first before they filed their own US application, they actually end up getting a denial. And a lot of times they'll say, oh no, like we actually have Paris priority because we filed in Australia before, this other one, the one that's blocking us, filed in the US. But if the one that's blocking them was filed in the US is already registered, meaning it's already cleared the registration process, been registered, the USPTO won't pull that back. And you have to then go through a cancellation process to claim your Paris priority. So the only way you can avoid that is by being really on top of it and noting that for your clients, and demanding your clients run searches and do the right diligence, and then follow up with the PTO appropriately, because there's a lot of issues with the delays in examination that actually complicate this ability to get this Paris priority. But if you're on top of it, and the client's aware that you have to spend time to consistently be looking for things to make sure the application's processing properly, that's good. But it's not as automatic as it should be. It's still a hand process at the PTO to figure out these priority dates, which is actually surprising that they don't have a better system for it. But nevertheless, that is what we're dealing with.
Another practice tip is to, if you are filing something based on a Paris Convention and there's already an existing application that is on your radar, and you file that, file a letter of protest. This is one of the few situations if it is close enough, then, and it's before registration, like Josh said, then they could claw it back. As long as that registration certificate is not issued, then the USPTO has the ability to claw it back, and they will. We've had situations where that's happened, even with an intent to use application that's been accepted. They will say, well, this should have been, I mean, it's rare because it's a 6-month period, and that's a little bit harder to thread the needle there, but they will cancel a statement of use and they'll say, all right, put it back in the queue and review it, because that's how kind of powerful these can be.
Yeah. I see a final question here we'll take since we're up against time. And then we'll give out the passcode that everybody needs and final instructions on how to get CLE credit. A question came in about, do we recommend outside search companies, or how should a trademark search be done? This will run the gamut depending on the client that you're working with and their budget. The one thing I always say is that if a client comes to us and says, oh, I've already run a search, I'm immediately, like, my eye roll happened 10 minutes before those words came out of their mouth, because there's only so much that someone can really look at online. The PTO database, you can search on it. It's not helpful in my opinion, because the difference of a space or a letter, you're going to get different results and you're not going to see what you need to see. So unless you have a professional search software with professional searchers, you're really not going to get all the information you need to make a proper evaluation of whether a trademark is clear, or whether there's a problem that's out there. As a firm, we've developed in-house capabilities. So we have searchers in-house that do the searches for our clients, because paying vendors is expensive. And by bringing that in-house, we're able to pass along those cost savings to clients. So we have that capability. A lot of trademark firms do not, and they will use the outside vendors. But definitely be very careful about clients trying to do their own searches online. I know it looks like they're getting good information, but most of the time, in our experience, they are not. I would estimate we are a few years away, but AI will eventually really help with this, but just not quite enough yet. So just like you don't want to rely on ChatGPT to write your brief for your next case, you definitely don't want to rely on an AI trademark search to give you a clearance report.